Start. The factual position is not in dispute. The charges against the respondent were of a serious nature, implicating acts of embezzlement and misuse of funds of the educational institution. The second aspect of the charge related to an allegation of obtaining appointment on the basis of fabricated documents. The respondent submitted a response to the charge sheet denying the charges. Admittedly, as the learned single judge noted, no date or time was fixed for the inquiry and no witnesses were examined by the management. The inquiry officer proceeded to record finding merely on the basis of the charge sheet, the reply submitted by the respondent, and the materials on record. The respondent was not associated with the inquiry after he had denied the charges, nor was any oral evidence adduced in support of the allegation of misconduct. Since no oral evidence was adduced, there was a cross examination. In other words, it is evident that absolutely no procedure was followed consistent with the principles of natural justice. After the inquiry was concluded, a notice was addressed to the respondent on 14 December 1993, stating that the charges had been proved and calling upon him to submit his explanation. Para. The contention of the respondent is that a copy of the inquiry report was not served upon him. This aspect has not been inquired into by the learned single judge, but the material on the record in the form of the counter affidavit of the appellant does indicate the position even according to the appellant. According to the appellant, though the inquiry report was submitted to the respondent, he denied receipt of the report, whereupon a copy of the report was submitted to him by a letter dated 18 December 1993, of which the postal receipt is dated 20 December 1993. Para. On these facts, there can be no dispute with the legal position that the inquiry was conducted manifestly in breach of the principles of natural justice. The charges to be inquired into were of a serious nature involving embezzlement and the obtaining of appointment on the basis of fabricated documents. Embezzlement involves the diversion of funds and the conversion of funds of the employer by the employee for his own personal use. These charges need to be established on the basis of material which must be proved in the disciplinary proceedings, and as part of that process, the employee must have a reasonable opportunity of defending himself, questioning the veracity of the evidence and adducing his own defense during the course of the disciplinary inquiry. In the present case, there was no inquiry at all. The judgment of the Supreme Court in Managing Director ECIL under bracket Supra holds that where a breach of the principles of natural justice lies in the failure to furnish the report of the inquiry officer to the delinquent employee at the disciplinary proceedings, the court should cause a copy of the report to be furnished if he had not already secured it. Over.